you. Thank you so much. Um, so
I think I'll choose Ryan.
Hi, everyone. My name is Ryan Getty. I use he, him pronouns. And let's see what was next. Where I'm from. I'm from a small town in Texas that no one's ever heard of, but I live in Fort Worth, Texas right now, which is, if you don't know where that is, that's near Dallas. So that's where I'm at as we speak. And my favorite Halloween activity, I don't know. It's a fun holiday, so it's hard to say. I think these days, every year, me and my friends have a costume party, and that's always a fun time. So I think that's probably my favorite Halloween activity. Um, let's see. Has Jeremiah gone?
he has not.
I'm Jeremiah. My pronouns are he, him, I'm pretty sure. I'm from Vernal, Utah. And my favorite Halloween movie is probably like Hubie Halloween. If you guys have seen that one, it's on Netflix. I like it. And then I like hunting in the fall and stuff. Really fun time. So right around Halloween. And then, yeah, that's probably my favorite part. And I'll do Jordan.
Hi everyone, I'm Jordan. I use she, her pronouns. I'm from Charlotte, North Carolina. And my favorite Halloween activity is probably the movie watching, which makes picking a favorite Halloween movie really hard, but I will go for the classic Hocus Pocus. Lavender, do you want to go next?
Sure. Hi, my name is Lavender. I use she, they pronouns. I'm originally also from a small town in upstate New York that probably no one has heard of, but I'm in Massachusetts right now. And as far as fall activities go, um, actually, yeah, I'll go with that. Halloween is also a holiday for me. Halloween is Samhain. And my favorite thing to do is get a bunch of friends together and have like a potluck style meal. I've done it for a couple years in a row now. And it's like my favorite thing that happens kind of all year. So, Elicity, do you want to go?
Yeah, I'll go. Okay, so my name is Felicity. Can everybody hear me okay?
We can.
Okay, great, great, great. My pronouns are she, her. I am from Indiana. My favorite Halloween movie would probably be Halloween Town. I'm big on Halloween, but not being scared. I don't like the scary part. My favorite Halloween activity would be the fun corn mazes.
I also love corn maze.
Yeah, they're really fun. How about Emily?
Emily, you were unmuted and now you are muted. I don't know if you can hear us. It seems like you're having connection issues tonight. But if you're able to hear us, if you could share, I'll put it in the chat. Why don't we give Emily a chance? I know I've seen her come in and out a lot tonight, and I know her broadband is not super. I'm gonna for now redirect us to Ash.
Hi everyone, my name is Ash. My pronouns are he, him, and they, them. I'm located in Oakland, California, and favorite Halloween movie would be Casper. the ghost. Yeah. Who has not gone yet? Okay, Andy. I'll go to Andy.
Sheikah.
Hi there, I'm Andy. I live in Eureka, California, which is pretty much kind of near the Oregon border. If you've seen the TV show Gravity Falls, that's kind of loosely inspired by the county that I live in. Even though the show creator set it in Southern Oregon, which doesn't look like where they put it or put it on a map. I use he, him pronouns, and at least recently, Halloween's kind of become less of an important holiday for me. As a little kid growing up, I practiced Dia de los Muertos with non-parental adult role models. And kind of over time, as I lost connections with them, I lost connections with the holiday itself. But about 2 years ago, I started doing a lot of family history research. And when I discovered this kind of rich history that I've been disconnected to, in particular Mexican American culture, I really found a lot of love for that holiday again and started practicing that. And so Halloween kind of just became the day before the holiday that I'm excited to celebrate.
Very cool, Andy. Thank you for sharing.
Yeah. Could I popcorn it to you, Abby?
Sure. I'm Abby. I use she, they pronouns. I am originally also from a small town in upstate New York and live in Massachusetts. And my favorite Halloween activity my favorite fall activity is either corn mazes or apple picking. I have always lived in places where both of those things are very prolific. So you will often catch me in a corn maze looking a little bit like a velociraptor, just trying to find my way around without tripping over anything. And my favorite Halloween movie would have to be Addams Family Values. I think the superior of the two Addams Family movies. I'm gonna go to Honora.
Hello, can you guys hear me? I know last time I had issues with my connection.
We hear you crystal clear.
All right, good. I'm Honora. I use they, them, and she, her pronouns. I'm from Idaho. And my favorite Halloween movies to watch. I love to watch horror movies and I watch them all year round, but my favorite thing to watch around Halloween is anything Tim Burton, especially like Sweeney Todd or Coraline. Those are my favorites. And then my favorite activity is the pumpkin patch. I would do corn mazes, but I'm horribly allergic to corn, so I just do the pumpkin patch, and I love pumpkin patches. So, who hasn't gone that I can popcorn to?
Sheikah.
Huh?
Sheikah.
Sheikah, yes,
Can
Sheikah's
you hear me?
left and Cecile.
All right, let's do Sheikah then.
Hi, I'm Sheikah, she, her pronouns from Georgia. Might be a little bit loud because I'm in the car. Going to Jacksonville for the long weekend, and I like walking in the parks for Halloween and just eating candy.
Very good. I also love eating candy. Really can't go wrong. So then Cecile and I believe Naomi, and I think that's Emily on the phone. So Sheikah, who would you like to popcorn to?
Cecilia.
Hi everyone. I am Cecile. I live in Idaho, and I don't have any favorite Halloween movie because where I grew up, there was not any holiday that is like Halloween, so I am not used to it. I'm still learning what Halloween is all about, but maybe someday I'll enjoy it. Um, I kind of love fall season because of the trees, the flowers are so beautiful, and leaves. So those are my favorite parts of fall season. Oh, and I use she or her pronouns.
Excellent. Emily, is that you who just dialed in on the phone?
Can y'all hear me?
Yes, we can.
Awesome, great. I don't know why the Zoom app's not working, but it was getting very aggravating. I do apologize.
That's okay. You're here, and we're glad you're here. If you could share your name, your pronouns, where you're from, and your favorite Halloween activity and or movie.
Okay, so my name is Emily Robinson. I'm from Grantsville, West Virginia. My pronouns are she, her, and my favorite Halloween activity would be handing out candy and decorating.
Excellent. And then last but not least, Naomi.
Hi everyone, my name is Naomi. I use she, her pronouns. I'm from Washington State on the Oregon, California side. Yeah, I really love Halloween, but my favorite thing is I actually took it upon myself to be like a nanny on Halloween. So I'll take the neighborhood kids trick or treating, and that's one of my favorite things of all time, I have to say. They're so cute and they're always just so happy. It's super cute. So that's one of my favorite things. So yeah.
That is
Thank you.
so fun. All right. I am gonna turn it over to our presenter this evening. Stephanie Woodward is the Executive Director of Disability Empower Her Network, and is also a disability lawyer. And she is going to be teaching us all about our rights as people with disabilities under the ADA. So Stephanie, please feel free to further introduce yourself, especially your favorite Halloween movies and activities. And we're good to go.
Hi everyone, as Abby said, I'm Stephanie Woodward. I am a pale woman with messy curly hair today. I have a logo behind me that says Disability Empower Her Network with two mountains intertwined and a horizon over top. And I use she, her pronouns. And I'm from Rochester, New York, the greatest place on earth. Please come visit. We're amazing. And my favorite Halloween activity and movie. So I believe that Halloween has already started, but my husband thoroughly has set a hard line that Halloween decorations cannot come out until tomorrow. So I am absolutely thrilled to bring out my Halloween decor tomorrow, both indoors and out. I've already started my pumpkin spice coffees and my apple cider, and I am excited to get the full-size candy bars and squishies for my trick-or-treaters. I don't mess around. This is my entire life, just waits for Halloween every year. So when it comes to movies, I cannot pick a favorite, though I do like TV shows that are scary. I think that adds an element. I've always been a huge fan of the Castle Rock series on Hulu, which is based on the Stephen King universe. I am very into Bly Manor. I know the first one was scarier, but Bly one had just like the ending that just wrenches you out, you know? So I'm just saying, like, it's all great, but if you need like a definitive list of amazing things, I can send that to Abby afterwards if you need to get in the Halloween spirit. Any questions on this more important topic before we get into the ADA? Well, that's just sad and disappointing for you all.
Hey, Stephanie,
Yes.
what's your favorite candy to hand out?
Oh my goodness. Okay. So I make a habit of handing out full sizes plus squishes in case anyone has a like allergy or eating disability where just food is not for them. So my favorite nut candy would probably be controversial here, paydays. I just don't think paydays are given out enough. Paydays and Babe Ruths, by the way, are the exact same candy. I don't care who you ask, look it up. They're the exact same thing. And I think Snickers is just way overdone. Every house gives away Snickers. I like to go unique. The least favorite of my candies in the chocolate world is Three Musketeer. Who wants just marshmallow? Nobody. Like, disgusting. I do like a solid Twix to give away for the non-nut category. And of course, for the chocolate free category, if you don't think Starbursts are the winner on that, then you're wrong, because Starbursts are the winner. And so that's my definitive list of the best candies. Although I like to go wild here. Sometimes I do old school candies or candies that you might hate, like Dots, Mounds bars. Those are good, y'all. Give them some credit. Again, if you need a ranking, I can also provide that to you. If you have not yet had a Chunky bar or a Sky bar, I recommend you give them a shot. And you can come to my house on Halloween to get them. I also give out Capri Suns because it can get really thirsty out there trick-or-treating. All right. Any other questions on Halloween before we get into the ADA? All right. Abby, I am not able to share my screen.
It would probably
Stephanie,
be helpful
I
if
have
I
one
let
more.
you do that.
Okay, great. You ask me another question while Abby gives me some permissions.
Nightmare Before Christmas. Christmas or Halloween?
There is no or in that sentence. It's an and.
I will start watching it tomorrow and not stop until January 2nd.
Which is the correct amount of time to be watching Nightmare Before Christmas. Thank you for the question. I think that was really important. Before I share the very important PowerPoint, I do just need you to see this picture of the outside of my house because this is what it's going to look like tomorrow, and I'm so excited. It is 3 12-foot skeletons. There is a coffin with a body inside, some graveyard stuff, a cauldron, and this is only half of my yard. So I just felt like that was more important than the PowerPoint that I now get to share with you. So let me change this up and get the correct PowerPoint going. Let's see what we can do here. I assume that you can all see this beautiful slide that says the Americans with Disabilities Act and Introduction. Am I on point here?
Yes.
Okay, wonderful. Do you see the actual screen or the fancy little note screen? Because I have 2 screens and I'm not nearly as young as y'all or technologically inclined.
We see the actual screen.
Wonderful. Love that. All right. So I want to caveat this with the Americans with Disabilities Act is a big and intensive piece of civil rights legislation with lots of regulations. Everything we're going over here today is really the basic 101. If you want to dive deeper into any area, I'm really happy to do that. And I'm happy to stop to do questions throughout, but I'm just caveating that we're going broad strokes here and not diving deep. So please don't think that this is all there is to know about the ADA. So when we're talking broad strokes, the overview of what we're doing today is we're going to do a quick overview of the ADA. We're going to break it down title by title because there are 5 titles to the ADA, and by title we just mean major section. Then we'll talk a bit about regulations and then resources for advocacy and enforcement. So we're going to start with the basics here. So the ADA, lots of people like to talk about the Americans with Disabilities Act, but when we talk about who it covers, sometimes we don't definitively know who that is. So the ADA covers 3, like, let's say, types of people, and one is like an outlier, but only in Title I, which is in employment. So let's go over those 3. A person has a disability according to the Americans with Disabilities Act if they have a physical or mental impairment that substantially limits one or more major life activity. So major life activity can be things like walking, seeing, but some of those things that you might think of right off the bat. But it can also be things like processing thoughts. It can be things like reading. It can even be things like your body producing insulin, because that is a major life activity, your body being able to produce insulin so that you can live. So that is what we're talking about when we're talking about a disability. That's your basic definition, and a lot of people fall under that definition. The next one is having a record of such impairment. So let's say that you had cancer and you are now in remission. If people want to discriminate against you based on the disability that you have a record of having, then you are still qualified as a person with a disability under the ADA. This can also be true of someone with, let's say, who has a history of epilepsy, who has had seizures, but hasn't had one in 7 years, but someone is discriminating against you on the basis of having had that disability. Or regarded as having such an impairment. So there are people who perhaps don't have the disability, but are being discriminated against because someone believes they have a disability. In that case, that would also be covered under the ADA. So some things might be, we have seen cases where a person has a facial difference, and that facial difference is not at all disability related. It's just a difference in their face, and people assumed that there was a disability because of the facial difference and discriminated based on that. So that would count as a form of being protected by the ADA. Now, the fourth one that only counts when employment is association with a person with a disability. And what that means is if an employer wants to discriminate against you because of your connection to a disabled person, then you would be protected. And this often happens in cases of people who have parents with disabilities or children with disabilities, where the hiring professional or the job decides to either not hire you or demote you or fire you because you have a person with a disability in your life. So let's say you have to take your kid to several doctor's appointments because of their disability, and your job says, well, we don't think you can handle this job anymore. Maybe you should look elsewhere. That could be a form of discrimination that would be protected under the ADA, even though the individual being discriminated against is not a disabled person. The discrimination is based on the association that they have with a disabled person. This also, in the early 90s, happened a lot to people who associated with people who had HIV or AIDS, which is a disability covered by the Americans with Disabilities Act. But there is now, and was even more back then, a lot of stigma around HIV and AIDS. So there were employers that would not hire someone because, let's say they were gay and they knew that they associated with other gay people and they assumed all gay people have HIV and AIDS, then that would also be a form of discrimination protected by the ADA. Two other important things besides definitions, because that was a pretty big definition, but two important things to me that I always like to point out to people is that the ADA does not allow for punitive damages. So punitive damages are punishment damages, which means that if you sue someone under the ADA, you can, the remedies, the fixes are that your exact costs can sometimes be covered, but the real remedy is the access. So if you sue someone because they have a step to get in, the remedy for that is the ramp. There is no, and the business has to pay $10,000 because they did something bad. This is important for several reasons. One, because sometimes we see news stories that are like, this person sued 10 businesses under the ADA, they are somehow gaming the system and they're bad people and they're leeches, because how dare this one wheelchair user sue 10 businesses that were physically inaccessible? Like, lawyers are just making money here, and this disabled person is some sort of leech, right? But let's think about it in the context of any other marginalization. If 10 businesses wouldn't let a person of color in and the person of color sued, we might have a different reaction. That like, hey, maybe the businesses are bad here. If we don't have that reaction, we should probably have some self-reflection on that, because it is pretty bad to not let marginalized people into a business. But the thing is, disabled people don't get any money. We can't get $20,000 from the restaurant with a one-step entrance. What we can get is a ramp. So it actually doesn't do us like any amazing good to sue these businesses. It just provides access. And you know what? If a disabled person is discriminated against at 10 different businesses and they have like the energy to sue all 10 businesses, more power to them, because they're not getting financial gain out of this. They're just making our world more accessible. So that shouldn't be an article online or an episode of 60 Minutes about how terrible they are. That should be a public service announcement to thank them for the energy they're putting into this. But not allowing for punitive damages is also really important, because it doesn't create an incentive for businesses to become accessible. If their biggest punishment for being inaccessible is that they have to become accessible, then what motivates them to do it right from the beginning? The thing I like to point out is, if a business gets sued and they have to pay $100,000, all of the neighboring businesses are going to be like, I don't want to pay that fine. Let's fix whatever it is. But if an inaccessible business gets sued and all they have to do is become accessible, then every other business on the block will be like, oh, well, then I'll just wait till I get sued. Like, it's not a problem until I'm forced to fix it. There is no incentive to get it right. Naomi, I see your hand is up.
Having this conversation on a committee I was on, and it was a lawyer, and we were talking about precisely like accessibility in businesses. And their argument was that people who didn't actually have disabilities were going around suing businesses for money. And so I was like, I'm pretty sure we're talking about, you know, accessibility and whether or not the businesses were accessible or not. So then would the fact that punitive does not allow for punitive damages, could that be an argument to say we actually don't get punitive damages, and so we might have to take a second look at the claim?
Yeah, so first of all, it would be very hard for a non-disabled person to sue for access under the ADA, because the very first thing courts look at is this person qualified under the ADA, meaning, do they have a disability? So I would be very surprised if you had some sort of region of the United States where non-disabled people are rampantly suing under the ADA, because in order to sue under the ADA, you have to be a person with a disability. Non-disabled people can't do it, because to be qualified to sue under the ADA, you have to be protected by the ADA. And the only people protected by the ADA are disabled people, and occasionally underemployment, someone who associates with disabled people. So that's step one. But step two, yeah, you can't really sue for a lot of money when punitive damages aren't available. So you get the access, you don't get any punishment money. I think that's a big flaw in the ADA. As a lawyer, I would love to see punitive damages in the ADA, because I think that it would make the world a lot more accessible, because businesses would have motivation to comply. I hope that was helpful. And then the next thing is, the ADA does not include a grandfather clause. Give me 1 second, Andy. I see your hand. Give me 1 second. The ADA doesn't include a grandfather clause. So we hear this a lot, where someone says like, oh, my business doesn't have to be accessible because we were grandfathered in. We existed before the ADA, so therefore we don't have to be accessible. It's simply not true. The ADA does not have any clause that says businesses built before the ADA don't have to be accessible. In fact, what the ADA does say is that when you have the resources to become accessible, so when it is not an undue burden is when there's a significant difficulty or expense. When it is not an undue burden, when it is a reasonable modification to make, you must do it. So perhaps your business in 1992 did not have enough money to get rid of your one-step entrance. But if you are still in business in 2023 and you didn't have the money from 1990 until today to become accessible, I'm really worried about your business. How is your business still functioning? That in the past 33 years, you couldn't remove one step. And by the way, on average, it costs about $500 to remove a one-step entrance. So that's why I use that as an example a lot, because it's a really easy one to fix. So there is no grandfather clause. When your business has the capability to do something, they are required to do it. So while you may not have had the finances or ability 5 years ago, this is a ongoing rolling requirement, which means you have to reassess your business as your business grows, as your business evolves, to see if you can become accessible. Andy, I see that you have a hand up, so let's chat.
I was wondering, have any states added legislation that in that state creates a punitive damage system?
That is an
kind of linked with the ADA?
So that's an excellent question. So states tend to have what we call human rights laws. So in each state, you might find it called something else, like the Division of Human Rights is often a common name we hear. And in different states, there have been not always punitive damages, but what we see is additional fines. So specifically in New York State, for example, if a person or a business discriminates against a trained service dog that is trained by an organization, then that business would have to, in addition to remedying the discrimination that happened, they would have to pay an additional fine on top of that. So not trained by the individual, which is a type of service dog that is allowed by the ADA. If I wanted to train my own service dog, I can. But if you discriminated against a dog or a person with a service dog that was trained by, let's say, Canine Companions or another organization that trains dogs, then you would have to pay a fine. And the last time I checked, that fine was $5,000. And that would be on top of whatever you have to do to remedy the situation. So there are other states who have done similar things, but not every state has done that. And oftentimes when states do it, they don't do it blanketly. Like if you discriminate, there is punitive damages. They will do it in certain circumstances. Like if you discriminate in housing or if you discriminate against the service dog, stuff like that. Naomi, I see you back.
I'm back. I have questions. So because I'm specifically associated with Canine Companions, I'm wondering, is there a lot of issues in like public accommodations? I try my best to be as as much of an advocate as I can with businesses, but I've ran into that in Washington State a lot, of whether or not Canine Companion service dogs are allowed, which technically they are, but sometimes you have to get a little technical. So are cases like that brought up a lot that you see?
Dog cases are really common, whether it's Canine Companions or individually trained or another organization trained it. There's a lot of discrimination when it comes to service animals. Like one of the most common ones is hotels trying to like charge a pet fee. Service dogs aren't pets. Uber and Lyft has gotten into a lot of trouble with discriminating against individuals with service dogs. In the housing realm, which is not ADA, but under FHA, which is the Fair Housing Act, there have been a lot of discrimination. So we actually, I believe one of my hypos later has a service dog in it. But in order for us to get to it, I'm going to pay attention to the time a little bit more, and I'm going to move on from my very first slide, I think. So let's get into Title I. Title I is employment. So remember we said titles are basically sections. So the first section of the ADA is focused on employment and employment discrimination and the rules and responsibilities of individuals with disabilities and also businesses when it comes to employment. So the ADA applies to only employers with 15 or more employees. But again, we have those state laws that we talked about earlier. I think it was Ryan had brought up that question. Some state laws, those Division of Human Rights laws, bring that number down. So I believe in New York, the number is 4 employees. So you might want to check your Division of Human Rights law in your state if you ever have a question about, like, this is a smaller employer, will it count? So Title I focuses on helping people with disabilities access employment opportunities and benefits that are available to people without disabilities as well. So it's not just about the opportunity, but it's about every benefit that comes along with the employment as well. The ADA prohibits employers from asking about a person's disability during interviews. So like, I'm a wheelchair user. In an interview, you can't just say like, so why are you in a wheelchair? We can't do that. Or like, how did you become deaf? We're not doing that. Tell me about what it's like to be autistic. We're not doing that. It also requires employers to provide reasonable accommodations to qualified applicants or employees. A qualified applicant or employee is a person who meets what is required in the job description and has a disability. So in order to be qualified, it's not enough to just like be a person with a disability. You have to be qualified for the job first. And if you are, but you need a reasonable accommodation to perform the job, then employers are required to do that. And reasonable accommodations come in all different shapes and sizes. I don't have the ability to pop things in the chat right now, but if Abby, you want to help me out and grab the Ask Jan link. The Ask Jan is the Job Accommodation Network. There's literally loads of resources there where you can figure out what accommodations might work for your best for your disability, how to write a reasonable accommodation letter, all of that good stuff. It limits medical examinations and inquiries. So you can't require a person to undergo a medical exam before you give them the job unless you require that of every single person applying for the job. So you can't say like, I'd hire you to be a trucker, but I'm gonna make you do a medical exam first. If you make every person that you're gonna hire do a medical exam, then sure, you can make the disabled person do it. But you cannot single out people with disabilities and make them do medical exams. Federally, this is enforced by the EEOC, which is the Equal Employment Opportunity Commission. So if you were looking for a federal entity to help you out if you get discriminated against and you don't want to go to your state level, which is the Division of Human Rights level, then you would take that case to the EEOC or to court directly. I'm going to go over some definitions with you real quick. We already talked a little bit about a qualified person with a disability. But this definition, I'm going to read it right off the screen because some people just are better with reading and some people are better with hearing it. So it's a person who meets the legitimate skill, experience, education, or other requirements of an employment position that they are holding or seeking, and who can perform what we call the essential functions of the job with or without a reasonable accommodation. And we're going to get to what the definition of an essential function is in like a second. But first, let's talk about what is a reasonable accommodation. A reasonable accommodation is any change to a job or work environment that allows that qualified applicant or employee with a disability to participate in the job application process, perform the essential functions of a job, or enjoy the benefits and privileges of employment equal to those enjoyed by employees without disabilities. Now, essential functions, this is an important one. We need to know it. Essential functions are the basic job duties that an employee must be able to perform with or without a reasonable accommodations. And the factors that we consider when deciding if it's an essential function of the job is the number of whether the position would exist to perform this function. So like if it's a mail sorter and you are not qualified to sort mail, the whole reason the job exists is to sort mail. So you're not meeting that essential function. We also look at the number of other employees available to perform that function or among whom the function can be distributed. So if I can't do this function, could someone else do it? Let's say I'm a lawyer and there is a function that like you'd have to be able to move big boxes of legal files. That's not that's not the main function of a lawyer. A main function of a lawyer is to practice law. But I can't move boxes. But if I'm in a firm with 10 other people, there's probably at least 5 other people who could move those boxes. So that's a factor to consider. And then the degree of expertise or skill required to perform the function. And the last thing is an undue hardship. So this is similar to an undue burden, but we use different wording when it comes to employment. An undue hardship is significant difficulty or expense, not only to financial difficulty, but also accommodations that are unduly extensive, substantial, or disruptive, or those that would fundamentally alter the nature or operation of the business. So one example is if you are a college student and you tell your college that in order for me to attend this college, that I am qualified. Oh, no, we're in employment. I can't do that example. Let me go to a different example. You're a lawyer and you tell your employer, like, in order for me to perform this job as a lawyer, I need attendance services. So I need you to provide a reasonable accommodation of paying for my attendant. Well, we would have to look at that. Does that change the nature and operation of the business for the law firm to start paying for something that is considered at more of a health realm? And it really depends on the firm and what they provide to other employees to decide, is this fundamentally altering the nature or operation of their business? Whereas it may in some, or perhaps it doesn't. So that's why we have to do an individual look each time. Abby, I see you. What's up?
So I wanted to provide a brief example that is actually not disability related, but how the essential functions and undue hardship can apply in many situations. I had a young person come to me who I am working with in another capacity, and they are doing some social media for this group that I'm working with. And they said to me, well, I'm giving up social media for Lent as a Christian. And since this is my religious practice, I need to be able to give up social media. And I said, well, my friend, social media is your whole entire job for me. So how are we going to make this work? I am happy to allow you to practice your religion, but what are we going to do? What kind of work are we going to do ahead of time to make sure that all of your duties are handled over the next month while you are staying off of social media? So we were able to make that accommodation for this young man, but it certainly was something we had to think about. And I don't think this is something that this young person, this was his first job in this capacity, so it wasn't something he had thought about before. Hello.
Thank you for that example, Abby, and thank you for the cat show. I'm a big fan. So I have 2 hypos, but I think we're going to just stick with one because we are running low on time here because I am terrible at apparently planning. So I'm going to go over this example with you and have us talk through this hypo. So Maria, who is a little person, applies for a job as an office secretary. She has all of the education and background requirements for the job. The job includes greeting customers, filing paperwork, taking notes at meetings, answering the phone, and sorting the mail into office mailboxes. The mailboxes are too high for Maria to reach, and they cannot move because they are built into the wall. The first question here is she a qualified person with a disability who can perform all of the essential functions of the job? And if so, what reasonable suggestions would you, what reasonable accommodations would you suggest, if any? So I'm going to quickly stop sharing to see what we come up with here. What are our thoughts, feelings, questions, ideas on this?
Please feel free to raise your hand or just unmute, or you can use the raise hand function in Zoom. Let us know what you think.
Let's start with, is she a qualified person with a disability who can perform the essential functions of the job? Ryan, I see your hand.
Well, I would say yes. There's no reason why she can't essentially do the job.
Why?
Why can she do the job?
I mean, she can't sort the mail, and that is part of the job description. So is she qualified?
Right, but presumably she can't sort the mail because she can't reach the mail, not because she's incapable of sorting mail.
Okay.
So that's what I would say there. And then in terms of accommodation, well, if I was the employer, I would probably ask her what accommodation she would like. But if I just have to decide, I don't know. I mean, presumably I would make several suggestions on accommodations related to reach if the main problem is the inability to reach the mail cubes or whatever they're stored in, a ladder or a step stool or whatever Marie wants, I suppose.
Ryan, anyone else?
This is Emily. I wouldn't per se give them suggestions, because reaching something, they've probably already adapted and have thought about how to accommodate that. So I would just ask them, how can we support you?
I think as an employer, that would be a great question to ask. But perhaps this is her first job having to deal with this issue. I'm wondering, do we have suggestions on what accommodations you would suggest if you were her friend trying to problem solve this with her? Anyone here think she's not a qualified person for the job?
I think she is absolutely qualified for the job. I think it is a reasonable accommodation request, and there's several things like the grabber thing. I know what I'm talking about. It has a handle, and yes.
Oh, yeah, they're called grabbers usually.
Do what?
They're usually just called grabbers, so we know what you're talking about, or at least I do.
Okay, and then a step stool or something like that.
These are great suggestions. Thank you, Emily. So yeah, why don't we suggest a grabber? Why don't we suggest a step stool? We could suggest, is there someone else at the office that can do the putting the mail in the mailboxes? What if she sorts it all and puts it in piles and says, this one goes in Mark's mailbox, this one goes in Lila's mailbox, and someone else just places it there? So there's lots of different ways that there could be accommodations. So yeah, Maria, definitely a qualified person with a disability here. It's really about what accommodation is going to work best for her. I'm going to go back to sharing screen. We're going to skip the next hypo because time exists still, unfortunately. And we're going to talk about Title II. So we're into a new section now. Title II is public entities. Public entities are state and local governments, all of that good stuff. So Title II prohibits discrimination against people with disabilities in all programs, activities, and services of the public entity. Examples of public entities can include your Monroe County Department of Health. It can include your police department. It can include your public schools. Anything that is a state or local government is a public entity. Title II establishes detailed standards for the operation of public transit systems. So your bus system, if it is a public system, there are rules for it under the ADA. This includes commuter and intercity rail. So think about like Amtrak, think about metros or subways, things like that. Title II outlines the requirements for self-evaluation and planning for governments. So governments have to actually evaluate themselves and make plans to become better and more accessible. Making reasonable modifications to policies, procedures, practices where necessary to avoid discrimination. Identifying architectural barriers. So identifying physical barriers for people with disabilities. Communicating effectively with people who have hearing, vision, and speech disabilities. And this is federally enforced by the Department of Justice. So if you're looking for federal enforcement of Title II, we're going to look to the Department of Justice for that. So let's get into some definitions that we need to know. A qualified person with a disability. Similar to underemployment, but ever so slightly different because we are not applying for a job here. So a qualified person with a disability under Title II is an individual who is disabled and meets the essential eligibility requirements for the receipt of the services or participation in programs, activities, or services with or without reasonable modifications. So an example of this, if you have a senior center that serves all seniors and one of the seniors is a person who is deaf, they're still qualified for the eligibility requirements to get benefits from that senior center, right? They're still a senior, all of that. So they're qualified to receive the services of the senior center with or without reasonable modifications. And a reasonable modification they may request is captioning, perhaps. But if a deaf person who was 30 wanted to get services from the senior center, it doesn't matter because they're not going to be discriminated against because they're deaf. They're being told they can't have the services because they don't meet the age requirements. The senior center is for seniors, and 30-year-olds, by definition, at least by this senior center, is not 30. It would be like 65 and up. So in order to be qualified, you have to meet the basic qualifications for whatever program or service you want, and then have a disability on top of that in order to have a qualified person with a disability. Being a disabled person is not enough. A reasonable modification. This is a modification to the rules, policies, or practices. It can also be a removal of architectural, communication, or transportation barriers, or the provision of auxiliary aids and services needed so the person with a disability can obtain that public service. So again, in the reasonable modification, in the previous example I provided was the deaf senior may ask for captions, or they may ask for an interpreter. And those are just two examples. They might ask for something different entirely to help them with communication. I don't know, I'm not them. And then a fundamental alteration. This is something we talked a little bit about earlier in the employment area, but a fundamental alteration is a change that is so significant that it alters the essential nature of the goods, services, facilities, privileges, advantages, or accommodations offered. So if the senior center is located at the center of town, and everyone can really get to it. It's available by public transportation. You can take cars to it. But a blind senior says, as a reasonable modification, I would like a volunteer to come and pick me up. That could be something that significantly alters the services that they provide, because they don't provide transportation services to anybody. They only provide services in their location. It's not like they provide services to other people. They just don't want to provide it to this person. They don't provide it to anybody. So that may be an alteration. But on the other hand, if they do provide transportation services to seniors, and then a senior with a mobility disability says, I also need transportation, but I need an accessible vehicle, then that wouldn't be a fundamental alteration of the service, because they do provide transportation to everyone. They just have to provide it in an accessible vehicle to this person, which is not a fundamental alteration of the service provided. All right, so we're going to get into some examples here. My first example is Jonathan. Jonathan is a deaf man and attends a Black Lives Matter protest. The police arrive at the protest and announce that they will arrest any person who does not disperse from the area. The police do not have an interpreter with them, but there is a volunteer protest interpreter in the crowd. Jonathan does not disperse from the area. The police arrest Jonathan. Jonathan writes on a piece of paper that he needs an interpreter. The police reply in writing that they will pass notes to Jonathan or use the protest interpreter. The protest interpreter is willing, but Jonathan refuses to use the protest interpreter to communicate with the police. The police also handcuff Jonathan behind his back. Jonathan physically indicates that he cannot communicate without his hands and he needs to be cuffed in the front before the police handcuff him. So 2 questions here. Well, 2 basics. Are the police required to use an interpreter? And if so, which interpreter? A police provided interpreter, or will the protest interpreter do? And then the second question, can the police handcuff Jonathan behind his back? Is his request to be handcuffed in the front a reasonable accommodation? So again, I'm going to stop sharing. Let's talk. Anyone have feelings on this? Give me someone new. Otherwise, I do that thing that happened to me in law school where I just call on people and it gets really awkward. Naomi.
So I believe that they can't use the volunteer interpreter because you have to be a certified interpreter, and therefore the police need to provide a certified interpreter, if I remember that correctly. And secondly, you can't technically handcuff behind, because that's just wrong on several reasons, but I don't think you're actually allowed to, especially if you're deaf. At least that's my interpretation.
All right, anyone else have thoughts on this, feelings?
This is Olicity. I can't use the raise hand thing, so can I go?
Yeah, Olicity, jump on in.
So I think that I think that I think they could have used the interpreter, the volunteer interpreter, and I say that because it's a form, it's Jonathan's form of communication. If the police can't understand him and somebody's volunteering to help, especially with this intense situation, I think they ought to just take what they could get at that point. Because I mean, the police could provide one as well, but that would be waiting for somebody to come from a station or wherever they're at to the scene, and that could take longer and it could get more intense instead of better.
All right, thank you, Olicity. I'm seeing Andy's hand.
Correct me if I'm wrong, but in the situation you mentioned that Jonathan chose to, or asked to wait for a official police appointed interpreter. And to me, that really seems like it would be his right, because the police by law under Title II are required to provide an accessible format of, in this case, arrest and questioning. And so even though there was a interpreter available, it is his right to have one, or have the agency that is interacting with him provide one.
This has been a really good discussion. I'm going to jump in here and break some of this down. So the first question was, are the police required to use an interpreter? Jonathan is deaf. His form of communication is ASL. Unless the police know ASL, which often they don't, unless you live here in Rochester, in which case some of our officers do. But yes, they have to use an interpreter for communication. Which interpreter? The police must provide the interpreter. Can you imagine this volunteer in the crowd is saying, I can do it. Did any of you watch Nelson Mandela's funeral? If not, Google it. On your break, go Google the interpreter from Nelson Mandela's funeral. You know what it was? A person who literally just made gestures with their hand who did not know sign language. Imagine an officer does not know sign language. Someone in the crowd says, I'm a volunteer interpreter. They don't know sign language. And now Jonathan is being arrested and having someone who doesn't know sign language just wave their hands. And the cops say, we provided communication. It's terrifying. Also, what if it's a college student? They haven't learned everything. Someone here said certified interpreter. The actual legal requirement is a qualified interpreter. That's really important because the one organization that was providing certifications for a long time stopped providing them. I think they're back up and running now, but like for a long time, it was really hard to get certifications anywhere. So you have to be a qualified interpreter. And if the police department brings it, police departments are required to do that. And oftentimes public entities already have contracts with companies or individuals that are qualified to do that interpreting. Now let's get to the handcuffs. Jonathan communicates with sign language. It would be impossible for him to communicate without sign language. With his hands behind his back, how would he even write a note? Now, this is a pretty reasonable accommodation in this case because in this scenario, Jonathan has not appeared to be violent or non-compliant in any way. The only thing he didn't do in this scenario is he didn't disperse when being told to disperse, but he's deaf. If they made the announcement to disperse, how would he know? So, for all I know, Jonathan has no idea he's supposed to disperse. He has no idea why he's being arrested. He's just asking for an interpreter and to have his hands in front of him. Not an unreasonable request. As a wheelchair user, I will always request that unless I'm being wildly violent, please either cuff me in the front if I'm in a power chair or do not cuff me. Because if I'm under your custody, but I have to be able to roll my wheelchair, it would be very hard for me to do that, to push two different wheels when my hands are like this. So that it can be a very reasonable request under the ADA. I think I saw another hand, but then it went away. Was it you, Cece? It's okay if you changed your mind.
I just wanted to give a comment on the area where you were talking about Jonathan. Yeah, that would be wrong if they cuff his hand in behind him, and that is the only way he can communicate. That they are violating his right, and it's against the ADA law. So they were wrong to do that to him.
Thank you, Cece. I appreciate that input. Abby, I think you're about to inform me that a break is required at some point, so I'm going to just preemptively give you this opening.
Okay, yes, let's take, before we go, Riley just said in the chat, interpreters also have a legal requirement to translate all messages accurately, which is why they can't use a random volunteer. I actually just watched a medical show recently where somebody's sister said, oh, I'll interpret for my deaf brother. And she interpreted to get done what she wanted done to his medical procedure and not what he wanted, which like this is fictional, but I can't imagine that this hasn't happened to plenty of people, which is why you should always use qualified interpreters and not your own family.
Importantly, this happens in domestic violence situations quite a lot when the police come and they try to use the hearing person, who is often also the person causing the abuse, as the interpreter. Can you imagine how scary that is when you call the police to get protection and they use the person who is abusing you to interpret what you're saying?
So on that lovely note, let's take about a 10-minute break and we'll come back at for me it'll be 8:20. For you that might be 7:20 or 6:20 or 5:20, but 20 minutes after the hour. So we'll see you then. Melissa or Larissa, our ASL using human is not here. So I will not be pulling her into a breakout, but maybe next week we'll see.
I like your moves, Andy.
Thank you.
Oh, hello.
Hi.
Let's come on back, everybody. Surprise, Stephanie. I'm at Stephanie's house. I've been here the whole time.
No, you just got here. Wouldn't that be better?
Yes. So in addition to Stephanie working at Empower Network and being an excellent lawyer, we're also related by marriage. So
I didn't marry Abby.
No. So I'm visiting my in-laws this week in Rochester, and I was like, wouldn't it be fun if we did the class together from your house? So here I am. And
I do think you're marriage material, though.
Thank you. Thank you so much.
Just not my marriage.
No, probably not, as you are, in fact, already married.
Yeah. But I like to think I bring the family together because I'm not sure that Abby's partner and my husband ever actually spoke to each other before I came along.
Very possible.
I brought the family together.
All right. Let's go ahead and get restarted, everybody. All right, Andy, I know you had asked if Stephanie was available while we were breaking. Did you have questions or comments before we hop back into a PowerPoint?
I had a question kind of stirred up by the example of the use of ASL, and I was wondering, I am by no means anyone even remotely close to being a qualified interpreter. However, I'm often the person in the room who has the most ASL experience. And so I've had a couple times where in public facing jobs where I've been tapped on to help in very kind of low stakes situations, helping someone who is an ASL user. And I was wondering, to what extent is that allowed of my employer, of myself as the person using sign, and kind of just how does that situation come into play?
So we talk about the term effective communication. For deaf people, first of all, not every deaf person uses sign language, but also sometimes having an interpreter is not a form of effective communication, like that really, that they're, of course they're going to be effective, but are they really necessary? If you're ordering a burger and fries, does McDonald's have to provide you an interpreter? No, because you can effectively order by writing what you want down pointing at the menu, things like that. Whereas if I'm buying a house and I'm talking to my banker about my mortgage, we need an interpreter for that situation. So we really want to think about the context of the situation. So if you're just working at a grocery store and someone asks you like, hey, where's the milk? And you know enough sign to be like, oh, the milk's that way, like totally fine. If you're working at a law firm and you're at the front desk and someone's looking for a lawyer and the lawyer pulls you into the meeting, we've got an issue. So does that help with context a bit? Okay, perfect. Again, my ASL, let's say we'll call it kindergarten ASL, and I'm pretty sure most kindergartners who use ASL are a lot better than me, but I've been the person in like public situations where I'm like, the guy, you forgot to give the guy his change. He's not gesturing at you angrily. That's sign language for where's my fucking money. There's a difference here. So, and give the guy his change. So I think context really matters. I'm gonna pop back to our fantastic PowerPoint and see where we can go from here. Let's see. All right. I think we're sharing the right thing. Yes. Fantastic. Okay, so we're gonna skip this because you guys probably want to get out of here on time. All right, so we're on to Title III. Title III is one of my favorites because if you're not employed, who cares about Title I right now? Title II, kind of boring to me. Title III is where it's at. I love Title III. Title III is literally everybody else. So it's a public accommodation. A public accommodation is so vast in definition. We're going to get to that. But essentially, Title III prohibits public accommodations from discriminating against disabled people. Title III sets the minimum standards for accessibility for alterations and for new construction of public accommodations. So I say minimum because everyone says like, oh, we meet the ADA. The ADA is the floor, people. It is not the ceiling. So just because you meet the bare bones does not mean you're actually accessible to all people. I just want to be abundantly clear. Just because something is ADA compliant does not mean it's the pinnacle of access. And then it requires public accommodations to remove existing barriers where it is readily achievable and not an undue burden. We talked about that a little bit earlier. We'll get into that again. It directs businesses and entities to make reasonable modifications for people with disabilities, and those reasonable modifications, same thing that we talked about under Title II, very similar definition. Now, there have been mixed court opinions on the application of the ADA when it comes to websites. Why? Because in 1990, websites weren't exactly like poppin'. If you want to see an example of a 1990s website, look for Space Jam. I'm pretty sure Space Jam has not changed their website since 1995. That is what we're talking here. Just websites, internet was not as poppin' back in the 1990s. Are you looking up the Space Jam website?
Yes,
I knew you would be.
Am I correct?
Yes,
that's
yes, I am.
beautiful.
Yeah, so if y'all are not looking up the Space Jam website right now, that's a pity for you. But there wasn't any regulation or definitions written about websites back when the ADA was created. So some courts are like, there's nothing that directs us here. Other courts are like, we know the intention of the ADA is access. So of course websites have to be accessible. So there's been real mixed opinions through the court system on that. And again, the ADA under Title III is enforced federally by the Department of Justice. So let's get into some definitions to know. As I said, for me, public accommodation means everybody else. So Title I, employers. Title II, public accommodation or entities. Title III, everybody's welcome to the party. So it is businesses that provide goods or services that can include stores, restaurants, bars, service establishments, theaters, hotels, recreational facilities, private museums and schools, doctors and dentist office, shopping malls, and other businesses. Nearly every type of businesses that are in the public are here in this, regardless of the size of the business or the age of their buildings. So the only things that aren't included here, religion, because as much as religious people like to say, oh, you're welcome here, you know who fought the hardest to be exempt from the ADA? The people who please welcome, except for when we have to accommodate disabled people, in which case we ain't doing that. And then private clubs. And there have been some rare circumstances, like think of like a golf club where you like it's a private club. But the moment they open their doors to being public, like if they hold the PGAs there, you lose all that protection and you have to comply with the ADA. And then readily achievable. That standard means that it is easy to accomplishment and able to be carried out without much difficulty or expense. So that's when we were talking about that grandfather clause. When it is readily achievable to become accessible, you must do it. So I'm going to go into both hypos here because I think we have time for it, and one gets a little bit more intense than the other. So Sips is a small locally owned coffee shop that has been open since 1985. For reference, the ADA was signed into law in 1990. So when Sips opened, they had a one-step entrance for the public to use and a ramp in the back for deliveries. In 2014, Sips renovated their front entrance and moved their entrance by 10 feet. The renovated entrance still has a step. Alex, a local wheelchair user, is upset that she cannot go into Sips. Alex brings a lawsuit against Sips for violating the ADA. Sips insists that they are not violating the ADA because they have a ramp in the back. Who is right and what factors do we need to consider here? I will stop sharing.
Are people allowed to like use the ramp, or is it only for deliveries?
That is a perfect factor that we would need to consider. Are other people using it, or is it just for deliveries? What else do we have to think about? Andy.
If folks are using the ramp as an accessible ramp, does it meet the building requirements for an accessible ramp created through ADA and the American Barrier Act? Architectural
barriers. Yeah.
Yeah, because a delivery ramp could be way steeper than a ramp intended for people who use wheelchairs.
What else might we want to consider? Anyone?
Don't be afraid to ask questions if you don't know, or to offer a thought. And even if it's wrong, we're all here to learn.
I don't tend to make people feel bad when they say silly things because I say silly things all the time. Do you want me to do the thing where I call on people so we can get real uncomfortable? Lavender, what are your feelings?
Hi. I actually was gonna unmute.
Oh, see, I knew that. It's my like.
Did you feel it? Did you feel the question brewing in my brain over here?
I did. It's because Halloween is coming and my special abilities are coming in too.
Well, there we go. I was thinking about like how much extra it would also like how much extra difficulty it would bring Alex, like even if the ramp happened to be accessible, like what does the terrain in the back of the building look like? And how much more is it going to put her out to like actually navigate whatever's back there, whether it be like a parking lot or whatever, in her wheelchair? Is that reasonable?
Love this factor. Thank you for bringing that up. Jordan, what are you thinking? You should think when you're not on mute.
Yeah. I am thinking not all ramps are created equal, but also, if they've recently renovated and it still has a step, like they had renovation budget, so it would be hard to say, oh, we didn't have it in the budget to do, an accessible proper entrance in the front when we took out the last entryway and replaced it with a step again.
That is very good. Does anyone else have thoughts before we dive a little bit more into this? All right, so I love everything that you guys are thinking. One thing that we haven't mentioned is where does this ramp go? We say it's a delivery ramp. Does it go into a main space? Does it go into the kitchen? Like, we want to know where we're going because you wouldn't believe how many ramps end up in the kitchen. And honestly, I wouldn't eat at least 90% of the places that I gladly eat at if I saw the kitchen. And I know that for a fact. I just know that. And I don't think I should be rolling through anybody's kitchen. I changed the name of this business, but this is a very real case from Rochester, New York, who very truly tried to defend this case and thought they were going to win. It very much amused me how much they had to pay legal fees, both for their lawyers and for me.
Is it the coffee shop that I like, or is it the other one that's downtown?
It's not a coffee shop, it's Jeremiah's Wings.
Really? I never would have gone there. I used to live right down the street from that place and went there all the time.
Monroe Ave, baby. They moved their business literally 10 feet to the left, new entrance. Left it inaccessible and said, but we have a delivery ramp in the back. Do I look like a delivery to you?
Maybe to some people.
I mean, special delivery here, y'all. I am not a delivery. The ramp looked like a freaking like straight, like I'm not a mountain climber. This ramp, as a manual wheelchair user who is highly in shape, not me, my husband, to be able to do it. You think my God, I get winded looking at ramps. Like, I'm not doing that. And it went through the kitchen. We're not doing that. But as my good friend, I believe it was Jordan, said, they made a renovation. The ADA says anytime you make renovations, those renovations have to be accessible. And they actually have a priority list. If you cannot afford to make everything in your building accessible, you start with the entrance. Then you move to pathways. Then you move to potties. Because ain't no point in a potty being accessible if I can't get there. But the ADA has a priority list. So you had every opportunity to make your entrance accessible and you chose not to. Yeah, no, that's just saying I don't like the ADA. You're asking to be sued then. And honestly, I enjoyed every moment of it. Riley.
I have a question. If like a business was replacing their paper towel holder, would that be considered a renovation?
If they move their paper towel holder and it's not in an accessible location, yeah, so it's not like I move my paper towel holder and therefore I have to make my front entrance accessible. But if you really replace a paper towel holder and you replace it to also be inaccessible, then yes. But truly, it's like if your business is investing in making like your kitchen better, you still got to make the front entrance better. So it's about that budget. One of my favorite examples of this, New York State invested over $1 billion into the New York City subway. I don't know if you've looked it up. Less than 30% of New York City subway stations are accessible. The disability community sued New York State and said, in $1 billion, you couldn't find it in the budget to make more subway stations accessible? New York State had the audacity to try to defend this claim, and they lost and had to allocate part of $1 billion of their budget to making subway stations accessible. Like, you would just think obvious. No. But let's say we're only making like a $10 improvement. We're moving our paper towel holder. You move that paper towel holder, it's already in an accessible spot, and you don't make it accessible, we got a problem. So anytime you make those, and honestly, with a paper towel holder, you have to move it anyway, because that literally is no cost to like move it the 2 feet down that it usually is. Like me trying to like stretch Armstrong it, just move it down. You're required by law anyway, because it's not much difficulty or expense.
For what it's worth, Jeremiah's also doesn't have a stall in their men's room, so trans men can't use the men's room at Jeremiah's. So
for all of you coming to Rochester, New York, don't go to Jeremiah's.
Even if their wings are really good.
Fuck their wings. If you want wings, you go to Buffalo. You don't come to Rochester. What's wrong with you? But we are the next best thing. All right. Focus, Abby. My God.
It's really inaccessible all over the place.
We were more productive when we were in different rooms.
I knew this would happen.
Oh, it's okay. I like you still. All right, let's go back to, because the next typo I really like as well, but now I have to figure out what page I'm on. Okay. This one is going to be more in depth. Rosa is a college student with an auditory processing disability and depression. Rosa has a dog named Kirby who helps her identify sounds in public and who helps her feel better when her depression gets intense. Rosa is studying to be a therapist. She has requested captioning in her classes and field placements, and her college has informed her that they will not provide captioning because she's not deaf or hard of hearing. They also informed her that they will allow Kirby on campus, but Rosa must first register Kirby with the school and provide medical documentation for him. Lastly, they told Rosa that she cannot bring Kirby to her field placement at the hospital because the dog would impact the cleanliness of the hospital and may upset some patients. Who is right, and what factors do we need to consider here? To be fair, I wrote this hypo and did not give you a lot of regulations about service dogs, so it's okay to ask questions on this for sure.
Erica said in the chat that her school had a service dog issue because of life-threatening allergies.
Yeah, so sometimes people's disabilities have conflicting accommodation needs, and we have to work through that as well.
We run into this a lot at the April conference. We are a cross-disability event, and we're a cross-disability organization. And Centers for Independent Living also have this problem. So it is a lot of working through how can we make this work for everybody, because we have to accommodate everyone.
And there was actually a really good case about this on a college campus when one girl in a sorority was allergic to dogs, and the other had a service dog, and the one with the allergic to dogs said that it like inflared her other disabilities, and so the court had to determine like, okay, so like what do we do when there's conflicting disabilities? We aren't on that right now, but I can get into that later if we have time, but given the clock, fat chance. But this hypo deserves some thought because there's a lot of factors going on here. Any questions, thoughts, feelings, considerations, ideas you have going on here? Andy.
Right off the bat, kind of the use of captions for a auditory processing disability, absolutely reasonable accommodation. And so the school neglecting to provide that accommodation is right off the bat incorrect. And then the nitty-gritty that you didn't quite go into of service dogs absolutely would allow for them to be in a hospital setting unless there's a life-threatening reason why that wouldn't be the case. And that would be on a very individualized basis. And alternate accommodations would have to be offered by the hospital in order to reject that accommodation request.
Thank you. Any other thoughts, feelings, ideas? I see in the chat, Erica asks, is Kirby a service dog? Well, let's read it. It says, Rosa has a dog named Kirby who helps her identify sounds in public and helps her feel better when her depression gets intense. So there are service dogs and there are emotional support animals. Service dogs are animals that are trained to provide tasks to assist a person with a disability. An emotional support animal just helps people feel better when they and it's often related to emotional or mental health disabilities. So like when I'm sad, my dog makes me smile. I saw Jordan first, then Lavender. Jordan, what you got?
I would say Kirby probably is a service animal. They've identified 2 disabilities and the specific tasks that the animal does related to the disabilities. But also, it's just weird that they would say captioning is for these folks with this sort of disability and not yours. Captions are like curb cuts. They benefit lots of folks.
I love captions are like curb cuts. That's going to be my new catchphrase. Lavender.
Yeah, I was gonna say, hi, I have ADHD and I have a bunch of issues with auditory processing, and I ask for captions with everything. Otherwise, sometimes when people are speaking, it just sounds like the teacher from Charlie Brown. Um, I can't understand anything, even though people are definitely saying things. So the argument that they're not going to give her captioning because she's not deaf or hard of hearing is there's no basis for that whatsoever. Lots of people benefit from captions, as Jordan said. And also, as far as I know, with a service dog, it seems like the process for that would be the same as with any other disability in like a university office. They can ask for a letter from a medical provider saying that she can have the dog. And please correct me if I'm wrong, but also with service dogs specifically, they can only ask, generally speaking, lots of places can only ask, is that a service dog and what tasks they provide?
Oh, magic that you know that. I love that you know the magic questions. Fantastic. Andy, was that like a hand or not a hand?
Question.
I'm ready for
I was wondering, because Rosa has identified that she has a disability and that the dog performs those tasks, and the service dog question wasn't asked, like that was that last person just suggested. Would the original, from our overview of the definition of what type of disabilities are, or definitions of a disability are covered, that would until that question is asked and answered otherwise, or with an answer other than yes, would that be considered discrimination against someone who is regarded as having such an impairment?
Well, if they are regarding her and discriminating against her because of her disability, yes. But Rosa has an auditory processing disability that does not seem to be up for debate here. Neither does her depression. So I think that she's already like a qualified person with a disability here, but the regarded as could be a factor if that wasn't pretty unargued that, yeah, she has an auditory processing disability and depression. But I gave you a lot of factors in here, so I'm going to go through them lightly, and I'm probably not going to hit on everything. All right, so Rosa, college student, auditory processing disability and depression. These are two different disabilities we're working with here, okay? Let's start there. Rosa has a dog named Kirby who helps her identify sounds in public and who helps her feel better when her depression gets intense. If it was only helps her feel better with her depression, that is an emotional service animal. You want to know why? Because that's not something she trained her dog to do. You don't train your dog to help you feel better. Like, your dog is not a nurse. Like, they're not trained to help you feel better. I have 2 dogs under me right now. They make me feel great all the time. They're so damn cute. They're trained in absolutely fucking nothing. Okay, like, useless in most cases. Not pass for service dogs. They can't even provide services for themselves. So no, but has been trained to help her identify sounds in public. Now we go through this test. What is the service animal test? Is that a service animal? That's the first question you can ask. Second, what tasks is it trained to perform? Identifying sounds. That is a service animal task. So service animals can make people feel good. That doesn't mean they're not service animals. It just means that they're really cute as well, or they're comforting. That doesn't make them less of a service animal. So that can trip people up because that can easily make you think that physically, that it's an emotional support animal, but in fact, it can be a service animal in this case, but because it is trained to do something. All right, so the next thing, Rosa is studying to be a therapist. She requested captions in her classes and field placement. Her college informed her that they will not provide captioning because she's not deaf or hard of hearing. So she requested captions because of her auditory processing disability. A school cannot categorically say we only provide this accommodation for these disabilities. But this is very much like businesses telling people with service animals, you're not blind, so I don't have to let your dog in. People just categorically decide what accommodations are allowed for which disabilities, which is ridiculous. But what the school can do here is ask for documentation that shows that she needs this accommodation based on her disability. Because it's the nexus test. When it is not obvious the person's disability or the connection to the accommodation, then you can ask for medical documentation. Now, I'm a wheelchair user. If they scheduled all of my classes on the 3rd floor in a building without an elevator, they cannot ask me for medical documentation if I ask them to move the class to the 1st floor. Why? Because my disability is obvious and the need for the accommodation, pretty obvious. You can see the connection there. They may not see the connection between the auditory processing disability and the need for captions. So they could ask for medical documentation there. What's next is they informed her that they will allow Kirby on campus, but she must register Kirby with the school and provide medical documentation for him. What typo did you see Rosa even ask them about Kirby? She didn't. You want to know why? Because he's a service animal. She don't ask permission for her service animal. That's her service animal. You don't have to ask for the accommodation of, can I bring my service animal? Because the answer is categorically yes. Under the ADA, your service animal gets to go with you. You cannot require someone to register their service animal. My good friend Lavender, I believe it's the one that they identified the 2 questions that can be asked. Lavender, was that you? I hope it was you. Because I might just be throwing out guesses at this point. You can ask, is that a service animal? And what tasks are it trained to perform? You cannot ask for medical documentation. I don't care if you're a school. I don't care if you're an employer. I don't care if you're the president. You can't do it. You can ask those 2 questions. This is a real hypo. I want to say it was University of Pennsylvania that was trying to do this. They did not do well in that case because it's pretty obvious that when you have a service animal, 2 questions, no medical documentation, no registering. Are you out of your mind? And yes, people still do this. In fact, Wayne County is the next county over. And quite literally, someone called me and said, my office is next to the Wayne County Fair. And I keep hearing on the intercom system, if you have a service dog, please come to reception to register them with us. And I was like, no. So yes, still happens. Literally was happening last week. Not allowed. And then lastly, they told Rosa she can't bring Kirby to the field placement at the hospital because the dog would impact the cleanliness of the hospital. Notice it's the school telling her this. The hospital did not say this. Right, as far as we know, only the school is telling her this. What? How does the school get to prohibit a dog in a hospital? 1, they can't. 2, the only places in a hospital where a dog cannot go, where a service animal cannot go, is sterile environments. Anywhere a human can go naturally, anywhere a member of the public could go, your doggy can go too. You can't go into the surgery room. Because if my mom can't go in with me, neither can your dog.
I would also like to point out that dogs regularly go to hospitals. They have therapy dogs that go to hospitals all the time to provide emotional support to patients and their families. So school is full of nonsense.
Now, what it might be a reasonable accommodation is if she has a therapist and her field placement is meeting with one person who has an extreme fear of dogs. As part of her mental health disability, a fear of dogs could be involved, then perhaps as an accommodation to that person, they could work out for that one client. Like, I'll have my dog in the next room when I meet with this person. But that would, again, would be an individual basis that they could work out. There's no reason to categorically exclude this dog from campus. So I think I went over a lot of the factors. I'm pretty sure I didn't get them all because I intentionally made this a pretty intensive question. I hope you enjoyed it. Any questions, thoughts, feelings, concerns, ideas on this one? Excellent. I'm so glad because we have like 8 minutes. So I'm gonna get going on this. All right. From current slide. Okay. These ones are real short. Title 4 is telecommunications. This one does not come up as much, but has created a great infrastructure specifically for people with communication related disabilities. So Title IV says that telephone and internet companies are required to provide a nationwide system of interstate and intrastate telecommunication relay services that allow individuals with hearing and speech disabilities to communicate over the telephone. So previously, before most of y'all existed in the world, we had TTY, which was like this little typing system. But now we have video relay service, which is where our interpreters can be seen on video and still communicate with someone on the telephone, but provide that interpreting via video, which is so much faster than TTY. Let me just tell you, I think everybody appreciates video relay. It does require closed captioning for federally funded public service announcements. And this is federally enforced by the FCC. So Title IV, pretty basic. We want communication access, and this is how we get it. Title V, which is miscellaneous. It's quite literally labeled miscellaneous. They might as well have just said like kitchen table, whatever we can't find a place somewhere else. Here you go. It's contains a variety of provisions relating to the ADA as a whole, including how it relates to other laws, because it can overlap with, let's say, the Rehab Act or the Civil Rights Act. So it kind of tells you, like, how does this work? How does it work with state immunity? What is the impact on insurance providers? Because insurance was real nervous about how letting disabled people out in the world could impact their liability claims, because apparently we are all just rolling, walking hazards. It prohibits retaliation and coercion against people with disabilities, specifically when we bring claims. And it provides a list of certain conditions that are not considered disabilities. For example, active alcoholics and active drug users are not people with disabilities. A person in recovery can be considered a person with a disability, but a person who is actively using and is an alcoholic or a drug addict cannot be covered by the ADA. All right, look at that. I still left time for us to talk because I'm just that good. So in the next 5 minutes, anyone want to chat about anything? Y'all just feel really good with the information I provided. I get it. Like it was.
You have a hand up.
Listen, no, we don't. Andy thinks it was perfectly comprehensive and has no questions. Hey, Andy, what's up?
Sorry, I keep raising my hand. I just wanted to state that TTY still exists, and that especially amongst folks who lose hearing later on in life, it's still a popular technology. The still I work at often helps folks set up TTY services for the first time in their life. So I just wanted to mention that it's still around.
Thank you, Andy. I talk about it as if it is a relic from the past, but much like ringback tones, not completely gone. So still used often like ringback tones by older generations or people who have recently lost their hearing. And because lots of deaf people who lose their hearing later in life do not know sign language. But before, TTY was our only option. Now it is, let's say, the lesser used option, because people who do use sign language very much prefer interpreters, because it just makes communication faster than typing everything out. Also, for people who are deaf, who English is not their first language, TTY could be very difficult, because if your primary mode of communication is not English, but you have to communicate in writing, that can lead to a lot of miscommunications. So it is easier for people who at least have English down as a solid basic in order for them to have the comfort level with writing back and forth to get information. I don't know where the Jonas Brothers came back. Oh my God, ringback tones. Yeah, okay. Yeah, so many of you are not old enough to know the embarrassment of ringback tones, but boy,
they were
a thing.
Instead of, when somebody would call you, instead of them just hearing your phone ringing, they would get to hear a song. Note that you paid money and you never got to hear the song. It was just when someone called your phone. And if you're like it ran out or went away for some reason.
Yes. So a ringtone is the song that comes out of your phone. A ring back tone is when you call me, you get to hear the song instead of bling bling. And mine, in case you were all wondering, because I know you are, was AC/DC's Shook Me All Night Long.
It was.
Yes. I'm not turning red out of embarrassment on that whatsoever. I'm actually just embarrassed I had a ring back tone, but it's fine. It was the thing to do.
So ring back tones or otherwise, does anybody? Ooh, Danger Zone, also a good one.
Oh, Jordan, I like compliments. I take them all the time. If anyone wants to follow Jordan's lead and just give compliments, I'm here for that. Or say happy things about Halloween. Also, big fan of that as well. Thank you, Jordan.
And we have Stephanie's number here at April. So if any of you have questions or comments or concerns or things come up after the fact and you want to reach out, I am sure that she would be happy to do that.
And you can send me presents anytime you want as well. Halloween themed
Halloween
ones
related
preferred.
presents. I have a present. It's your ramp in my car. Definitely was going to leave here, not leave here.
All right, we have precisely 1 minute. I'm gonna be quiet so Abby can do the things that Abby does.
Abby, the interpreters can't hear you.
Yeah.
Thank you.
There was no little mute button on yours.
I disconnected from audio, so I didn't hear everything twice.
Oh, that's so smart.
So reminder that your journals are due at the start of class time, but on Tuesday of next week. So that would be what day of the week? I would have been prepared for this. September 5th, at whatever time class starts for you, would be September 5th. To your assigned person. I will continue to send out the list because I even had myself mixed up with who people were supposed to send things to, and Riley and Erica very kindly reminded me what that list was today. So the journals y'all submitted were excellent. Thank you for putting thought and time into them. If you didn't submit for this week, please make sure you get that to myself or Erica or Riley as soon as possible. Otherwise, I think we're all good. Most of you, I have your travel stuff. I think the only people I don't have travel set for, let's see, Jaden, I don't have your travel stuff yet. I think you were booking your flights, and then Rachel, I will reach out to Kendra to see what's going on your end. Yeah, Cece, that was fine. Thank you for sending. I ended up sending it along to Riley. All right. How can you? So, Jaden, can I give you a call tomorrow? Is that okay? Cool. All right. Have a yes. Is that Rocky? You've got.
No, this is Bully.
Is that Bully? Yeah.
This is Bullwinkle.
Say bye, everybody. All right. Thanks, everyone.
Love you.
Have a good night. I'll see you next week.
Miss you. Love you. Bye.